Hey, everybody. Welcome to another exciting webinar. We're going to have a lot of people rolling in from the Law Insider community. We've had so much excitement about talking about data terms. Y'all, like this is what you guys get up in the morning and get all wound up about is data terms and AI and cloud services contracts. Who knew? I'm Mike Whalen. I'm Chief Community Officer at Law Insider. As you guys are coming in, do me a favor. We're going to start right on the hour. So do me a favor and just tell us where you're coming from. It's always interesting to see where in the world you are. I'm in suburban Kansas City today, left our Chicago place to come get some dental work done with the kids. So if you guys could tell us where you are, we'll get started right on time today. I had a question, just FYI, about the recording. The recording will be available. We'll get the slides, put them in a PDF. We'll send all that out. That will be after the presentation. It takes as long as it takes to get things up on YouTube. So everybody's joining in. I see countless people, hundreds of people rolling in to talk about data terms. You guys are special, kind of nerd, and we love it. Let us know where you're coming from. All right, we're starting on time. David Tollen has a lot to say today. We have had interest. One of the trends that we've seen as we put information out is that people are really excited to learn about software-related contracts. So we decided to get the guy who literally wrote the book. David Tollen is one of the industry's leading authorities on software licenses and contracts about all these issues that are coming up: artificial intelligence, cloud computing, all the technology. He wrote the book, the Tech Contract Handbook, published by the ABA. He teaches at Berkeley. He's got the Tech Contracts Academy, which we'll talk about later. So before I introduce David, I just want to give you a little bit of logistics. David, if you let me just take a moment. We are leaving open two things: the chat function and the Q&A function. We will not be able to address Q&A until the very end. David has a lot of meat to give us today. So we'll try to address questions at the end, but even if we cannot get to them, I'm going to ask you to put questions in the Q&A. It lets us respond to questions later. It tells us directionally what people want to learn about. So ask the questions even if we can't get to them, and we as a community will get to them in time. The other thing that we have is the chat feature. Go to the chat feature, and I hope what you'll do is talk to each other. If there are questions that David can address, or you want to say, hey, in my jurisdiction, this is true. We actually tried that, communicate with each other. We really want that. So use those two things. We'll have a couple of polls to ask you about yourself as we go through. But in general, we're going to roll with the content. As I mentioned, David Tollen is the authority in this space. We're talking data terms and AI and cloud services contracts. I'll turn the time over to David. Remember, use the chat, use the Q&A feature liberally. We will get to them. David, it's all you.
Thank you very much, Mike. Thank you for the both the kind introduction and the invitation in the first place. I'm delighted to be working with Law Insider, a great organization. So yeah, we're here to talk about kind of an oddball topic, and I don't mean oddball in terms of data terms being some sort of side issue. It's a quite central issue in contracts about the cloud, where the vendor holds the customer data, and contracts about AI, which is usually provided via the cloud. So again, the vendor's holding the customer data. And then in machine learning deals, the vendor's doing quite unusual things with the data. What makes data terms kind of unusual is that they are so burdened by misunderstanding, particularly misunderstanding of intellectual property, of the nature of IP and how it applies to data. So that's where we're going to start. This is our agenda on the screen. We're going to start with the problems that arise from this idea that you can own data, from the very widespread misunderstandings of intellectual property that gives us a sense of more value to saying we own data than there actually is. We're going to turn there to the key terms you want to think about if you're trying to control your data in your contracts, which is terms on data control, terms that say what the other party can do with the data. Both of those sets of issues are going to run into some complicated problems when it comes to machine learning. Machine learning throws a wrench into some of our normal assumptions about data terms. So we're going to run into that over and over again. But we're then going to look beyond that. We're going to talk briefly about compliance with privacy law. And I don't actually mean compliance. I mean terms in your contract that address compliance. Obviously, we could do an 8-hour course right here and now on privacy compliance itself and not come close to finishing, but we're not going to do that. I'm going to give you some some things to think about when and where and why you might promise to comply with privacy law, a regular request in data terms. We're going to talk briefly then about a sort of hodgepodge of additional data control related terms. And then we're going to turn to the other least understood topic in IT contracts, at least in my experience, which is indemnities. And we're kind of going to get the clash of these two things because we're going to talk about data indemnities. So we're going to address the very wide misunderstandings of the role of the indemnity. And we're going to see that the problems arising from not characterizing indemnities right are worse when it comes to data terms. And I'm going to give you, I hope, some guidance that will help you flesh out and understand those issues. And I hope leave with a better understanding both of data and of indemnities themselves, a much misunderstood concept. So that's our agenda for today. Just briefly want to mention, just sort of clarify something in the title. So, our title is AI and Cloud Services Contracts. Those aren't separate topics. So the cloud services is the term that I use and a lot of other people use to refer not to a technology architecture. That's not the right way to look at it. It's a business model. The business model of cloud services is that the vendor holds the technology. The vendor holds the application software and software as a service. The vendor holds the platform software in platform as a service. The vendor holds the computers in infrastructure as a service and provides remote access to the customer. So it's not about the cloud sort of architecture, all that kind of stuff, although there's, that's in there. The point is that this is a deal where the vendor is holding the technology, the customer never gets its hands on it and just accesses it remotely. As you can probably imagine from defining it that way, there's no inconsistency between AI and the cloud. It's not a separate topic. If you're working on, Chat GPT lately or Anthropic Claude or any number of AI systems available, you didn't get a copy. You're not downloading it onto your computers. It's provided through the cloud also. So look at AI as one option for providing technology via the cloud. There's a newish term, not as new as you might think, but a newish term, AIaaS, artificial intelligence in the cloud. And I kind of go back and forth on whether we've added anything other than confusion to our vocabulary by adding that. I mean, if the AI qualifies as a software application, it's just software as a service. But anyway, the simple and good category to use is cloud services. So we're talking about cloud services, including a big, very visible one, artificial intelligence. So quick note before we dive in about some resources available to you that will make, I think, even the next hour more useful. So you see there a picture of my book that Mike kindly mentioned, published by the ABA. All of the clauses from the book, all of the sample clauses are available to you for free at techcontracts.com. So you don't have to have a copy of the book. And so you might feel while I'm talking that you should, furiously scribble down terms that I'm talking about. A, you'll get the slides. B, just about all the contract language I'm going to talk about is there for you to copy and paste at techcontracts.com. It doesn't come with all the explanations that are in the book. That's a separate thing. So I'd love for you to buy the book. But anyway, the terms are there. I think note-taking is great, but don't feel the need to furiously scribble down contract language. So other things just available to you that I want to point out in particular, there's free articles and stuff at the website too. And one in particular, I think might interest this audience. It's that one linked down there in the third bullet, Artificial Intelligence Contracts and Issue Spotter. I wrote this 40 point, very substantial issue spotter on drafting and negotiating AI contracts, because I think our main job is to catch the issues. If we catch the issue, we can research it. We don't have to know the answer. We got to catch the issue. So this raises the key issues that relate to AI contracts. So that's all available to you. That link will take you right to the article. All right. So that's where we're going today. Let's dive into our first topic. And this is to be blunt, kind of an upsetting one for many. I get angry comments from lawyers a lot of times when I say this. You can't really own your data. It's this idea that you're going to say in your contract, we own the data, and that you've then achieved something and you can move on is really a misunderstanding. And it's based on a wider misunderstanding that is typical of the technology industry, even some of its lawyers, of thinking that you can own ideas. So you go to receptions, in my part of the world, the Silicon Valley, you hear people talk about our IP all the time. What are they talking about? They're not talking about their patents. They're talking about stuff their company knows. Stuff your company knows is not IP. Neither is data. Data is just plain information. And so think about it. How would you own your data? Do you have a patent in information? No, you certainly don't. A patent requires an invention. You may have a patent in the database structure or something like that. You're managing it, but the information, no. Do you have a copyright in your information? The starting answer is almost certainly not. You didn't write it. You collected it. It's not a work of authorship. So you don't have a copyright. There is such a thing, many of you have probably heard of, a kind of weak form of copyright called a compilation copyright, where you can have a limited right to keep others from exploiting your compilation of information. Like you might remember from law school, for most of us, the phone company cases where the phone company was trying to protect the phone book. And they argued that this was a compilation. There's no copyright in a phone number, of course, but they didn't want other people to steal the phone book and produce their own. And they argued for this compilation copyright. Actually, that argument didn't always work, but there is this weak concept. So you might have a weak compilation copyright, but it does very little. It's not, here's the key, even if you have it, it's not going to keep your other party who has access to your information from mining your data. It just doesn't. It might keep them from reproducing it and reselling it, but it's not going to keep them from mining it. That's what you're worried about. You don't want people to exploit your data. Your possible copyright doesn't do that. It's not even that reliable to keep them from reproducing it. It's because it's a weak form. Trade secrets. Is your data a trade secret? No, there might be a few in it, but the requirements of trade secret are not consistent with almost any substantial database. So where does this leave us? I'm not quite here to tell you, don't worry about ownership. I'm not quite here to tell you ownership as a result of what I have said is irrelevant. It isn't irrelevant. I like the compilation copyright argument. I like that, maybe we can sort of drive home that we do have some trade secrets in the data. So I want to say, when I'm representing whichever party is, has the claim to the data, I want to say I own it. My real point is, say it, recognize you've achieved very little, and move on to something more useful, data control. You are taking contract terms about data control, and you're using them to supplement the weakness of intellectual property. You're saying IP doesn't protect me. I'm going to protect myself with contract terms. So what do I mean? So first of all, let's look at language you could do to do that. Look at that language there in the middle where it says harder, but okay with carve-outs. So here's language you could use reasonably to seize ownership of your data, and then you move on. The parties recognize and agree that Data Co. owns the data, and that A, this is good stuff because here I'm going after that compilation copyright. The data is valuable property of Data Co. B, the data includes Data Co.'s trade secrets. C, the data is an original compilation pursuant to copyright law. Definitely compilation copyright. D, the Data Co. has dedicated substantial resources to collecting, managing, and compiling the data. You've done about all you can when you said that to claim ownership of the data. And that's okay. What I sort of want to ask you to think about is what about the other side? What about the party who is giving up on data ownership? So this is not ideal. No language that has you, let's say you're the vendor of software as a service, AI as a service, whatever it is. No language that has you conceding that the other party owns the data is a really good thing. Why is that? Because you don't know what's in the data. Your stuff could be in the data. Third-party stuff could be in the data, which you then might want to use in some other setting. To just blandly say, okay, it's your data is a bit risky. In fact, a lot of times the customer wants the vendor to go so far as assign any IP rights it might have to the data. And I'd really recommend you resist that. There is a difference between assigning rights to data and acknowledging that you don't have rights. So look at that first bullet. This is the best for you if you're the vendor. Data co claims ownership of the agreement. You're not agreeing to anything. The vendor is other co. And the agreement does not transfer to other co any title or other ownership rights to the data. Right there, you're saying to your customer, relax, we're not claiming it, but we're also not giving anything up. Maybe you go further. Maybe you do that stuff, the 4 bullets in the next sentence. The one thing I recommend you always do is that you put in some carve-outs for just in case the data does turn out to have your own stuff in there. I mean, your customer could have put stuff from your AI's training data or your manual or whatever into their data. You want to have NDA type language. NDAs usually carve out, say if information was independently developed or independently received, you've all seen this language, isn't covered by the NDA. You want to have a carve out like that for data too, whether you're assigning, which I hope you won't, or just agreeing, recognizing that the other party owns the data. You want to have that cautionary carve out. Let's move on to a couple. I want to, before going to the more important topic of data control, I want to leave you with a couple of other concerns as they specifically relate to machine learning, artificial intelligence systems. So here we have systems that are producing brand new content, software code, text, images. Many of the images here on this slide deck I created using AI. All the cool ones with robots, because that's my best way to represent artificial intelligence. This image, however, is the famous monkey selfie. You may have heard of this. A monkey took a picture of himself, and there was a battle over whether there's a copyright in it and who owns it. And the courts ultimately held there's no copyright because there's no human author. Same deal, so far as we know, with AI creation. The Copyright Office in the United States, at least in 2022, said human authorship is necessary. Pure machine authorship, no. The machine's like a monkey, no copyright. Thaler v. Vidal, 2022 Federal Circuit Court said roughly the same thing for patents. Human has to be the inventor. So you might be saying, well, we need to own the outputs, the data, the code, whatever it might be that is spit out by our machine learning system, our Chat GPT or our co-counsel, if we're using one of those legal generative AI systems, whatever it might be. What are you going to own? The human beings working for the vendor probably weren't involved in creating an output. You send in a prompt, the machine gives you an answer. The only way they could have IP rights is if one of their humans got involved, and that didn't happen. It was your human and their computer. So the vendor probably has no IP to give you related to data or any element of outputs. And so you just don't gain that much looking for intellectual property rights and outputs. Now, this is a particularly American analysis. There's little lighter views in the United Kingdom on contribution. The American law is not at all clear. Where's the line? At what point can the output be? What level of human cooperation, quote unquote, with the AI will still allow a copyrightable or a patentable output? That remains to be seen. Pure AI looks like, no, not going to happen. So there's a lot of uncertainty around that. The other side of machine learning is you also have to think about the data you put in. So as the customer, you ask a machine learning system a question. We call it a prompt. It's widely called a prompt. You might even provide training data for the machine learning system. A lot of corporate systems have the customer add to the data that the machine is trained on in order to further train it for your specific needs. And you might, any other input data might go in. And sometimes your prompts, people ask 8-page prompts full of data, including, disclosing the company's trade secrets to ChatGPT in order to get a recommendation on writing software around the new project. So you got data going into machine learning systems. So can you get the vendor to say, customer, hereby owns all of that data? Again, great if you can get that from your vendor. But when you're on the tech vendor side, I've got a concern for you. You don't know what went in. You don't know if they took pieces of your existing training data and went in, and you don't even know what's going to come out. The systems are so complex. You don't know what third-party materials the AI is going to pull off of the web, its original training data. It's kind of risky for the vendor to say, customer, you own and we recognize your ownership of all of the prompts, training data, or other input data. The vendor be smarter to, again, do what I recommended before, just acknowledge we're not getting ownership of this data because you give it to our system. The existence of the prompt, the existence of the training data does not mean that we gain ownership. By the way, a final caution on this you really need to be aware of on the customer side. Most systems where the customer puts in prompts or training data will not, at least corporate systems that you buy, they're not going to reuse your prompts as training data for another customer. That's not how they work. If you're retraining the system with your own training data, the system's only that specially trained version of the system is only going to serve you. But some systems, that's not the case. Some systems, every prompt, every training data that goes in continues to train the model, which means your data could come back out as the answer to some third party's, some stranger's prompt, including information you put in. You don't know what form it's going to come out, but it could. So you got to be aware. You need to know before you do any deal. Do customer training data go into training your model? And if so, is that version of the model limited to us, or can third parties take advantage of it? You'll learn pretty quickly when you ask the vendor to agree that the data won't be used for any other purpose than to serve you. And they say, no, we can't agree to that. But you want to know that going in, because that might not be a system you want to use. All right. That's our concerns about ownership of data. Let's talk about the more valuable stuff that, at least for the customer, or really it could be the vendor, whoever it is who needs to own the data. Where's the, where do we get our real value here? And it's data control, it's use of data. So we're recognizing we got our IP rights, whatever that may be worth, but we're recognizing that it didn't get us much. It doesn't actually, even if there is a compilation copyright, it doesn't block our vendor from scanning our data for marketing related information or sending marketing messages to each of the customers' names they find in the data. That none of that has been achieved by saying we own it. And little else has, but a few things. So what do? Contract terms. So that first bullet you see there on the screen, solely to serve customer. Vendor shall not access or use the data except to provide the services to customers, something along those lines. That's 80% of your battle. Right there, after ownership, saying that whatever data use that is going to be made, it will be solely to serve customer. Now, in those machine learning deals I talked about, that should be feasible if the machine learning isn't being trained for the benefit of third parties on your data. And we'll get back to that concept. So right there in your cloud deals, you've largely secured your data with that one sentence. Usually there's going to be some exceptions, and I think you should be flexible on them. And if you're on the vendor side, you certainly want these exceptions. Cloud vendor could be sitting on a mountain of valuable data. That's a really, really valuable asset. And so the cloud vendor wants to keep it if they can. And the way to do it is to clean it up, to strip out the personally identifiable information from the data. So that's that bottom bullet point there, aggregate data. You want to de-identify the data. What are you going to do? You're going to do something like take all of the personal names in the data and replace them with a serial number or something. So you can tell individuals apart, but you can't tell who they are. And the idea is then the vendor says, once we've done this to your data and all of our other customers' data and aggregated it, so it's, you know, even harder to find out what's yours. It's all in one messy pile together. Now we've got our valuable asset and it doesn't have really sensitive data in it. Can we just use it? Can we have it? Vendors, you always want to look for this if you can get it. Customers, it's not unreasonable. I want to make customers aware of a couple of concepts that might help you. De-identified and truly anonymized mean two different things in the industry. De-identified means what I just said. You pulled all that personal information out, maybe replaced personal names with serial numbers. Truly anonymized means you left no way to reconstruct it. So let's say I'm the vendor, I pulled all those personal names out and replaced them with serial numbers, but I kept a list of those serial numbers and the names they correspond to, just in case I ever want to put it back together. Now there's a risk to the confidentiality and privacy of that data. So the data, if you say truly anonymized, that's at least the industry term for that you didn't do that. And I recommend customers, you go for that concept. You go for the concept of truly anonymized. By the way, don't just use those terms. You never want to rely on industry terms in a contract. Use them, but define them, because there's, you know, different, the California statute, the CCPA used de-identified to mean truly anonymized. I mean, it's gotten muddy. So define the terms. Final concern about that, just to be aware, giving somebody aggregate data could turn that person into a controller under GDPR or other data privacy laws. It's a concern. It's going to depend on the law in question. You know, maybe there's an argument, well, what are we a controller of? There's no private data left in it, but it's something, sadly, you got to look into case by case, whether this creates a concern. All right, quick note about doing all this if you're in the weird world of machine learning deals. Again, we're saying we're not going to use the data for any purpose other than to serve the customer. Well, can we do that? Again, back to the customer's training data, its prompts, its input data. If all it does is use that to generate outputs, fine. The vendor should be able to say, we will not access or use the data except to provide you with the system. If it uses your prompts and training data to train your copy of the system, again, they should be able to say that. But if it uses your prompts and training data to train the broader model, you're going to run into a wall. They're not going to make that promise. In fact, they're going to want you to confirm that anything, if they're smart, anything you put in could come back out in answer to someone else's prompts. Outputs, ownership of outputs. Interesting question, whether we're talking about ownership of data or a work of authorship. I'd say data, because the Copyright Office won't call it a work of authorship. But anyway, should be easier to get that kind of restriction where the vendor says, we won't use the outputs that you create from your machine learning system for any purpose whatsoever. Again, vendors, if you're smart, you're going to have those NDA type carve outs that I mentioned. You're going to say, we're not agreeing to restrictions on information that we independently received or that we independently generated. That's really important. All right, let's move on to our next topic. And we're going to go through this and then we're going to take a quick poll. So let's do this. This topic's relatively brief, but another sort of data related issue, particularly in cloud deals, that you really need to think through, and that I think people don't, which is, do you want to promise to comply with privacy law? Seems obvious. It's the law, you know, the customer wants the vendor to promise that it will comply with applicable law, applicable privacy law. You see those terms in contracts all the time. If you're on the customer side, you have probably also once in a while run into something really distressing, which is the vendor who says, no, we're not making that promise. No promise to comply whatsoever, or we're going to make a really limited promise. I bet a lot of you have seen this, We're going to promise to comply with the data laws that apply specifically to us in our place of business as a controller, whatever it might be. And they've really narrowed it down so that you're worried there are laws applicable to your data they're not promising to comply with. Well, I think some people's natural reaction is to say, well, we're dealing with criminals here. They won't even promise to comply with the law. I didn't realize we're in bed with the mafia here. We're just going to have to go do a deal with somebody else. I want to encourage both sides to look at this a little bit differently. So first of all, I think we should all recognize the law's the law. It doesn't need your promise to comply. If the law applies to you, you're supposed to comply, period, end of story. So you don't have to promise to comply, and by declining that promise in a contract, you're not saying you're not going to comply. What happens when you promise to comply with law in your contract? You double your potential liability if you don't comply, which in the privacy world, we're going to do by accident again and again. So we fail to comply. We are, we do something wrong under GDPR, under CCPA, under one of the, many other privacy laws popping up in the US and around the world. We didn't know we were not in compliance. What's going to happen? We're in trouble with the government. Yeah, definitely. It could happen, at least. We're in trouble with private consumers. They may have rights of actions against us. I'm the vendor in this situation. That's we. Why would we add breach of contract to all that trouble? And that's all you do by promising to comply. We know we're in trouble if we don't comply. And this is particularly relevant, I think, here, where we're talking about privacy. This is why I have this exhausting looking, frustrated guy surrounded by paperwork as my picture here, because privacy law has exploded in the last few years. Even just understanding GDPR and figuring out what's the current state of the law has gotten really difficult. If any of you is, outside counsel and does privacy related work like we do, you're in this awkward position of constantly telling your clients, not here's the answer, but how much privacy liability are you willing to risk? I mean, often we don't have the answers. We don't know what data is going to be in the deal. A lot of times, neither side knows in advance. Where's the data going to come from? What laws will apply to that? So it's actually not the act of a criminal to say, we're not going to promise to comply. I encourage you, if you're asked to promise to comply with privacy law, to decline, to say, no, of course we're bound by the law. Of course we respect the law. We don't want to add this. Or maybe if you do promise, to limit the remedies. Now, there's a caveat to this. There are some laws that specifically require contract terms promising compliance. So you got to know your applicable privacy law. You got to know if you're in one of the jurisdictions that has that requirement. And in that case, yeah, you promise to comply. The other just side note I want to make here is, why promise to comply with your privacy policy either? I see this all the time. Not just the other side is asking you to comply with your privacy policy, your standard form says it. Privacy policy is not a contract. You got to understand that. It is a customer-facing promise. I'm sorry, it's customer-facing policy. It's a policy on the wall of the building informing the public in general, not your contracting party, informing the public in general what you're going to do with data. It's not a contract obligation. And like compliance with law, you're in trouble if you don't comply with your privacy policy. So why add that to your contract? Again, there might be situations where there's a legal reason you really need to. In the absence of that, I'd say don't do it. So it's sort of a different look at ever more difficult, ever more frustrating topic of trying to comply with privacy law. It's obviously a whole other set of courses. IAPP, International Association of Privacy Professionals, has great ones. It's not something we teach in detail, but an ever more difficult field, and it's getting hard to comply. So think about what you actually promise in the contract. Don't create terms that could be used against you in another dispute. All right, that brings us about to the half hour. Why don't we do our poll, and then I'll move on to the next topic, which is additional data control terms.
Yeah, so we're going to do a quick poll and then a quick reminder on the poll. Speaking of protecting data, want to make it so that David can tell you about more of his courses, more of his offerings that'll teach you about technology contracts, but I need you to raise a hand. So if you will go in this opt-in poll, raise your hand and say, yeah, David, let me know, what else can I learn from you? He will reach out to you. So do that real quick. And then the second thing is just a reminder, we have the ability when you all ask questions, even if we can't address them during the time of this webinar, we have the ability to export all of those questions when we're done here. And we can turn that into future trainings. We can turn it into Q&A that we turn into a blog, however we decide to do that. So my point is ask questions, even if you don't think we can get the answer in during this time. So please jump into the Q&A, ask those questions there. The chat is a little bit different. It's obviously, as you can imagine, much harder to find those things. That's mostly for you engaging with each other, but please use the Q&A feature liberally. Josh, I think we're probably good on the poll. What do you think?
Yep, all good.
All right, good.
All right, David, back to you, buddy.
All right, good. So, and back again to the questions. I'm eager for them. So we will answer questions as many as we can. It looks like there will be lots, but we'll answer as many as we can in the last 8-10 minutes or so. I've left time for that. All right. Additional data control issue. Remember where we are. We've said data ownership is of value, but giving us relatively little value. It's not very consistent with intellectual property to control an asset like data, as opposed to a work of authorship or an invention. So we're controlling it with contract terms. What you have here on this screen is sort of you call it a smorgasbord of contract terms that also address data control. Location. Are you going to restrict where the other party, usually it's the vendor, not necessarily, but usually where the other party is keeping your data? You may have native laws like GDPR in some cases that restrict where data can go. A long-term problem between the United States and the European Union, as you mostly probably know, is their low trust in our privacy and government interference and an ever-changing landscape on whether data can be shared with the US. But there's other jurisdictions. I mean, you see clauses that I think are worth including, even though they're so obvious. Our data will not be housed in a data center in Iran, North Korea, Syria, and nowadays Russia, where actually that's actually something that could have happened. Anyway, terms on location of data are worth considering. By the way, when I represent the customer in our deals and I'm doing this data stuff, a lot of what I do is I throw the kitchen sink at the vendor, all of this stuff in the first draft. And by kitchen sink, I mean the extensive data terms at techcontracts.com, the website I mentioned, there's a long list of customer favorable terms. And then there's a short list of vendor favorable terms. I throw all the customer favorable terms at the vendor with no illusion that they're going to do it all. It's a fishing expedition. I don't want to just rely on the due diligence that went on before I got involved in the deal. I want to ask for everything the customer might benefit from and see how they respond. And that's good information gathering. So yeah, I'll throw in the location terms, even though I don't know what they're going to do with it. Other things to think about: customer access. Does the customer get access to data in a cloud system? Obviously, you get to go into the system, software as a service, whatever it might be, and play with it, but you might also need the raw data. So it's worth considering terms that allows you a mechanism to download a copy of the raw data and also to translate it to, sometimes the data is essentially in a language that your computers can't understand. And so you need the vendor's help to deaggregate the data, to turn the data into something readable by more general computers. By the way, on the vendor side, if you're asked for that, I don't think it's unreasonable to charge for that service. I don't think that has to be an automatic free service. I think it's really important for the customer to get it, at least in many deals. And by the way, that's also valuable for e-discovery. If you can get your hands on all of your data that your vendors hold, you can keep your vendors out of the discovery process. You can make sure that all discovery requests come to you, customer, so you can control what's answered rather than, a subpoena going to your vendor because that's where the data is. Deletion. It's always worth thinking about not only requirements that the data is deleted at the end of the relationship, or maybe even kind of regularly, but also the standards for deletion. Deletion is not as magical and instant a process as we think. We think we erase it and it's gone, but there's layers and layers of information saved on hard drives. So there are standards of deletion. National Institute, NAID, what does it stand for? National, I forget what it stands for, but NAID has standards for data erasure. And so it's worth looking at their standards and incorporating them into your deal. Big kahuna is technical security. That's a technical document. If you've been in any of my trainings, you've heard me say, yes, we should review the technical documents, even if we don't write them, because they tend to be crucial and they tend to be badly written. And our job is to make them well written. So review the technical standards and help make sure they're clear. But technical security, encryption, locked cages, all that stuff is big stuff. And then staff security, right to access only for need to know. Background checks, not legal everywhere, but doing background checks on employees, really valuable. So that's kind of the final sort of set of clauses. And as I mentioned, a large, very customer-friendly data management security clause is at techcontracts.com and in my book, the Tech Contracts Handbook, but free in the former. And there's also a shorter vendor-friendly version where the vendor is going to offer much less, frankly. All right, let's move on to our final and probably hardest topic, and that's data indemnities. And part of why it's so hard is because indemnities themselves are so hard. They are really heavily misunderstood. And this includes by experienced attorneys. So the first thing I will tell you, which for some of you at least may begin to disrupt your thinking about the indemnity, is it is not a remedy for breach. It is not a remedy for wrongdoing. It doesn't exist for that purpose. It isn't written to achieve that purpose in any way. We think of the indemnity as a punishment. We think of it as the other party promising they're going to protect us if they do something wrong, but that is not really its role. So I'm making a distinction here between first party and third party indemnities. A first party indemnity can look like a remedy for wrongdoing. In a first party indemnity, somebody says, the indemnitor says, if XYZ happens and you suffer a loss, I'm going to protect you. I'm going to reimburse the money. Whatever the loss is, I'm going to make you whole. That's an indemnity. We don't have first party indemnities very often in IT contracts. They're very rare. We usually have third party indemnities. A first party indemnity can kind of be used like a remedy. It's like a warranty. There's an interesting question why you would use an indemnity in that case instead of a warranty, and we can get into that. But we don't tend to have first-party indemnities in tech contracts. We have third-party indemnities, and they say something much more limited. They say, if a third party sues you about X, Y, or Z, and they define what the indemnified claim is, we will defend the lawsuit and pay settlements or judgments and protect you from that lawsuit. Think about that. Does it matter if the indemnitor did anything wrong? No. Think about the typical intellectual property indemnity. It's not triggered by vendor wrongdoing. You don't write if the customer gets sued for patent infringement for using the vendor's technology and the suit is valid and there actually is infringement, the vendor will defend. No, you just say the vendor will defend, period. It's the vendor's product. The vendor's going to defend that case. That's a typical intellectual property indemnity. And the idea is you've identified a type of case that you think one party or the other should be responsible for. Intellectual property is a good example. It's really the vendor's product. It's the vendor's thing. It makes sense. The vendor might want to control all that litigation. So you don't have any qualification that the vendor has done something wrong. So the indemnity works as a system for getting the parties to cooperate. That's the starting point of looking at this clause that is usually negotiated as if it's a club to hit the other party over the head with. Look at it as at least a third party indemnity. It's terms about how we're going to cooperate if a third party sues one or both of us. It's a cooperation clause. It's not a perfectly even cooperation clause. It does put more burden on one party, and it's because the two have agreed that it's a case that's more about that party's business. That's how indemnities work well. That's what the third-party indemnity is meant to do. It's meant to facilitate cooperation. By the way, it should facilitate your negotiations to look at it this way, to not put this element of blame into the negotiations. We want to punish you if you do such and such. No, we want to agree that these types of cases are your problem and these other types of cases are our problem. And so that, what determines whether you should do an indemnity, whether you think that one party faces kind of an unusual risk of third-party lawsuit just as a result of cooperating with the other. Indemnities work well. And if you've negotiated with a lot of the big, really, really big, super global tech vendors, you may have heard a statement like, we only grant indemnities when they're going to work well, when we think the two parties are going to be on the same side, which may be a reason you're not going to get this indemnity. So everything I just told you about how an indemnity should work, you now have to question. Now, at least not question, because I'm just not wrong here, but there's a problem when you go into a data indemnity and some other types of indemnity. So in theory, we should be able to do the same thing as we did with an IP indemnity. If there's a data breach from the vendor's computers, the customer and the customer gets sued. It's a breach of the customer's data. And the customer gets sued by third parties, consumer class action, government, whatever it is. The vendor's going to step up and defend because it was the vendor's computers, data breach indemnity. And that's, if we could do that, that'd be pretty similar to the IP indemnity. There's no particular conditions. It's our computers, it's our technology, boom. But the vendor won't do that. Why won't the vendor do that? In this case, unlike with IP, the vendor is aware that the data breach might not result from its activities and omissions. The data breach could result from the customer failing to protect passwords, from the terrible security on the customer's systems, which allowed hacker to get into the vendor's systems through the customer's systems, from the customer's employee leaving a laptop running in an airport and after she got on her plane. All of these things could lead to the data breach. And so the vendor's not going to do what you really should do in an indemnity and say, we're going to defend this type of case. They're going to put in a qualification only where we caused it, or only where we breached Section 9, the data management security terms, or only where we violated applicable privacy law. They're going to put some kind of, or only where we're negligent, some kind of restriction. You might think, fine. What's the problem? Why is that a big deal? That does create a big deal. It messes up the indemnity in a way that some tech vendors will say to you, we just won't do it at all because of this, because we're not looking at a case where the two parties would be on the same side. Hypothetical. Vendor has a data breach. Customer gets, and it's customer's data. Customer gets sued. There's an indemnity, like one of the ones I just described. Customer says, vendor, you defend us. We've gotten sued by third parties. You defend us. Vendor says, nope, we didn't cause the data breach. You did. We're not defending you. All of a sudden, we have a big problem. All of a sudden, this stops working well. So you might think, well, who cares? That's going to be resolved by the court. The court will decide who's responsible for the data breach. Probably not till the end. And the defense is now. So does the vendor defend the case, or does it risk having spent all that time and money on something it ultimately doesn't have to do because the court rules in its favor? Does the customer defend, or does the vendor let the customer defend the case and risk the customer doing a bad job or settling for too much and then suing the vendor for that money for breach of the indemnity clause? So the vendor has hard choices. The customer has hard choices. If the vendor's not defending, do we settle? They might say, well, you could have won if you kept fighting. So, you go after, it's a mess. And it's worse even than that. It's worse even than that because of this thing on the next screen, which I call the duty to defend law. This is a common law principle in many jurisdictions, including, I believe, most US states. If there's any question of fact about whether the indemnity applies, the indemnitor defends until that's resolved. So you're the indemnitor's counsel. You did a great job writing that indemnity clause. You limited your obligations. You're only on the hook when you are when you caused the data breach. You did a good job. All of a sudden, you didn't cause the data breach. You're absolutely sure you didn't cause the data breach, but because there's a dispute about that fact, now you're defending the customer. The whole point was not to defend the customer. And it's worse than that. The customer's saying you caused the data breach. You say they caused the data breach. Can you hire one law firm to defend this? You might have to hire two law firms, one to defend you, one you're paying to defend the customer while it's accusing you. The cost of defending this has gone up. Final problem, while you two are fighting with each other, you caused it, the plaintiff is sitting back and going, oh, thank you. Thank you for creating this wonderful record that one of you caused this data breach. I mean, the record just gets better and better from their point of view. So this is a mess. And I'm not saying it means you don't do data breach indemnities. Data breach indemnities do get done, but very sophisticated vendors will often say, we're absolutely not doing one because of this issue. Other vendors may be less conscious of the details of this issue. I call this advanced indemnities. This is very, very complicated. And if you haven't followed every detail, don't worry. I just want you to know the broad strokes. This is really complicated stuff. By the way, subchapter 5 in my book, The Tech Contracts Handbook, goes into this issue in detail for those who want the punishment of diving into it. And I'm not saying you need to. The question is, what do you do about the data breach indemnity? Some vendors will do it, but they'll say, we're going to limit it. We're going to put a maximum. We'll make a limit of our obligations on it. We're not going to have to spend more than $1 million on this. Some will mutualize it. Believe it or not, having the customer also indemnify the vendor for data breaches caused by its wrongdoing, they're each indemnifying the other. It doesn't make it cleaner. It makes it messier. Each party has these problems. But the weird thing is now it's not just the vendor who has to deal with this mess. The two parties are sort of in it together. They're, I think, more likely to cooperate. But as I said, a lot of times the solution is that there's no data breach indemnity. If you're on the customer side, don't fall into the trap of saying, oh, that's disastrous, because now you can, leak our data and you have no consequences. That's not true. Remember what I said at the beginning. The indemnity is about a defense against a third-party lawsuit. If the vendor leaked your data and you did a good job, maybe using my terms of creating a data management security clause, and they breached that, they have liability. Maybe you go for a 3x cap on the limit of liability under the data clause or something like that, or 5x cap. I mean, this isn't about liability. This is about defending a third-party claim. A final quick point I want to make about this, and this is, and then we're going to take questions. And this is really a side issue, but it's something I want to warn you about and leave everybody thinking about every time I talk about indemnities. We just talked about the possibility that you could solve the problem by saying the indemnity is limited. We got a limit of liability on the indemnity. Limits of liability restrict damages. They say damages for breach will not exceed X, and they will not include consequential or other indirect damages. Indemnities are not damages. The obligation to indemnify in a third-party indemnity is an obligation to perform. So if usually the limit of liability doesn't apply to an indemnity, and that's not an issue. But if you want to limit your indemnity obligation, my advice is don't rely on the limit of liability, because you'll get into a complex common law debate when the time comes about whether the obligations in the indemnity count as damages. And I think there's a very strong argument that they don't. And that includes the damages the indemnitor might have to pay to the third party. That isn't damages in the relationship between the contracting parties. And the limit of liability limits damages in the contracting parties. This is another complex topic I mostly just want to make you aware of in our last sort of minute. You got a link here to an article where I explain it in detail. Even more important, you got a solution, left-hand bottom box in yellow. Instead of relying on the limit of liability, add this clause in your limit of liability or indemnity section. Indemnitor is not required to spend more than X dollars pursuant to the indemnity, including without limitation, attorney's fees, court costs. You've eliminated any complicated common law battles about damages and what they mean and any of that kind of stuff. I don't know who's going to win that battle. It's going to depend on the jurisdiction. That the answer is not always going to be the same. but you've eliminated the risk. You've made it very clear what the limit of your indemnity is. So if you want more explanation of that, you can click on that article and see it explained more, but it's part of what I told you at the beginning of this indemnity section. Indemnities are not punishments, remedies, they're not damages, it's an obligation to perform. All right, that brings us to the end. Mike, I assume we have questions.
Yeah, I want to ask you, David, I want to share a couple of pieces of information with the folks at home, but I'm going to ask you to look. I told them to ask you questions, and they did. There are 43 in there. So take a look at the Q&A section and spool up a couple of those while I go over this. Okay,
All right,
so
great.
A couple of things for you all. We found as we tried to get people to show up for these things that they're like, but we don't ever do special offers. And we're like, but you're going to for Law Insider. So we twisted David's arm and he was kind enough to create this special offer. If you go to the link, and I'll ask Josh to share the link in the chat as well. If you go to that link, we've got an exclusive discount. Specifically, I want you guys to look at the master class. It is a master class, right? Like it covers a lot. So go to that. In exchange for that, I want to ask you all to do me a favor and go to David's. David is one of the cool kids on LinkedIn. So I'm going to ask you to go over to LinkedIn and just tag him, publicly share that you enjoyed David's webinar, that you thank him for joining the Law Insider community. I just shared his information, but just tag him on LinkedIn. Make sure everybody knows that David is a really good resource. Those are my requests. And the final thing is we're going to add a survey at the end of this so you can help me figure out what you all want to learn about in the future. That's very helpful. So go get this discount to the course, say hi, and thank you to David, and finish the survey at the end of this. With that, we'll get to a few questions.
Yeah, and I'll just throw in real quick too, the master classes are amazing, we think, and they cover just about every clause you get. It's about 8 hours. We also have recently released on-demand programs. That's the bottom line there. There's 3 on-demand programs up, and there will be more soon. So please check those out too. So there are a ton of questions. I'm gonna get to them as many as I can. So the first one just disappeared because the list is self-scrolling, but someone asked about, so I was talking about ownership of data, and somebody pointed out, well, data should really be governed by confidentiality terms. And that is right, or rather the way to look at it is this. IP and confidentiality are often confused with each other, but they really are entirely separate concepts. It doesn't matter who has IP rights in a thing if you want to put confidentiality restrictions on it. And yeah, you certainly should put confidentiality restrictions on data. I don't recommend using non-disclosure terms for data. The NDA was written for trade secrets, a form of intellectual property. And really the overlap between confidentiality and IP is strongest when you're talking about trade secrets, because confidentiality is part of the ingredient you need to share a trade secret without losing your IP rights. NDAs, confidentiality clause, written for trade secrets. Data management and security clauses are written for data, and it is a mistake to rely on NDA terms for trade secrets. So as I mentioned, you've got lots of examples of data management security terms, including the one that I provide you, a couple I provide you at techcontracts.com and in the Tech Contracts Handbook. Those terms, confidentiality terms have restrictions on how long things stay confidential sometimes, creates a trademark problem, a whole other issue. They have stuff that ceases to be confidential when you would never want your data to cease to be confidential. They have many, many ways in which they don't fit data. And they say so little, NDAs say so little about the details of protection. So use data management security terms. That's your better area for protecting data. All right, let me hit another question. Why would vendor indemnify defend for a data breach involving customer data? Why would a customer want a third-party vendor to step in and defend them in the event of a data breach involving their data? The more appropriate remedy seems to be a reimbursement of certain agreed upon costs resulting from the breach, e.g. notification, credit monitoring. I actually think that's a good point. I mean, it runs counter to the reality a little bit because a lot of customers really, really do want that protection. But there's an argument for saying we will defend ourselves with our major lawsuits, but we want a very high cap on liability for you, vendor, if it turns out we got a big loss for that lawsuit. So we want a breach of contract claim available. The flip side of it is I think a lot of technology customers, the litigation budget isn't there. They just don't want to have to deal with these kinds of cases. And if you do imagine like a master contract where there could be just massive amounts of data leaked in a big incident and it impacts hundreds of companies, you might not want to wade into that morass. You might want your vendor defending you, and the vendor, if it's large enough, might be in a better position to manage and centralize that litigation. Question from Tatiana B. Would LOL be inapplicable to both first-party and third-party indemnities? Really good and interesting question. I think that the answer is yes, inapplicable to both, but the waters the already muddy waters get muddier for the first-party indemnity, because there you can argue, well, this is kind of like a warranty. So the argument in favor of my position is the indemnity doesn't talk about damages, liability. It just says, I promise to reimburse you for the following losses. And it sounds like performance, not damages. But because it's so much like a warranty, because it looks so much like damages, you might have a court that says we're going to treat it like damages and therefore the limit of liability applies. So I think your odds are better on a first-party indemnity. By the way, what I've said is not guaranteed true on a third-party indemnity. You need to find out what the law is in your own jurisdiction, or just save time on what may be some very complicated research and put in the language I've recommended so that you don't have to worry about where your jurisdiction lands on this very complicated question. There's lots more questions, but we're at the top of the hour. Do I have time for one more?
Yeah, let's do one more. And don't forget, we will have the ability to export these questions, everybody. So again, if you have any, jump in there real quick, drop them in. We'll be able to export that and use it for future content. So David, let's do one more and then we'll wrap her up.
All right, let's see. What is your best, I like this one. What is your best trick for getting potential customers to not use, we are hiring a painter for our office's MSA for the SaaS purchase? This is a pet peeve of mine. So you're representing the vendor and they give you the document, the master agreement that they use to buy, let's say, hypothetical number one, they're giving you the document they use to buy all services. Problem number one that you might point out to them is you've misunderstood. We're providing software as a service. Ignore the word service. We're not really providing services. It's hosted software. You're still buying software. It's the industry made a questionable choice, decades ago to call it services, but it's really hosted software. The other thing that might be going, so that's your best argument there. The other thing might be going on is they throw the same contract at everybody. You're buying pencils, janitorial services, airplanes, whatever it might be. They throw the same contract at everybody. And you say to them, look, your terms are about more typical products. We provide software as a service. It's unusual technology. You don't get your hands on it. There's all these limits on it. We're going to spend more time just correcting the errors in the form before we even get to negotiating substantive things than you would just reviewing our form, which, while maybe it's vendor favorable, we'll admit to that, it is already structured to be correct and to relate to our type of product. We're willing to negotiate where you see it as vendor favorable, but let's save so much time trying to turn a contract for pencils and cars into a contract for SaaS, which is a completely different purchase. Good questions. Good questions all. Thank you.
Oh, and there's so many. Y'all will export this and use this in the future. Speaking of, we're done. I'm going to ask two questions. Reminder, go to David on LinkedIn. Thank him publicly if you can. David, thank you for joining on this. We want to make sure that the world knows how useful and helpful and genius you are. And also, as you leave this webinar, it's going to ask you some questions. Please finish that survey. It helps me to know what programs you want to see in the future. Obviously, you all have a lot of questions, so we want to make sure to address them. Thank you all. We will see you at the next webinar. We've got one coming soon, so make sure to check your email as they come from Law Insider. David, thank you again. We'll see you online and out in the world. I appreciate you.
Thank you so much. It was a pleasure.
Goodbye, everybody. Thank you.